Let's go ahead and talk about Minnesota's law that forbids anyone from under 21 from carrying a firearm and the legal challenge trying to take down that law. What's up, Wolverines? My name is John Crump, and I'm an investigative journalist, and this is my channel, John Crump News, where we discuss 2A every day. So if you want to know about things going on in the gun space, this is the perfect place to be. If you would do me a big favor, like, comment, and subscribe, it helps with the algorithm because it's engagement, and engagement is key to getting my voice out there. Today is the 15th of February. And since we're in February, that means that we are doing Bella's Wish. Bella was my niece who died of brain cancer 3 years ago. And every February, we are fulfilling her wish, which was to give toys and supplies to families and to the kids who are suffering from cancer. Every February, we do that. So I will be listing a link down below to an Amazon wish list. You can order it and just send it to Jessica D's address. It is the registry address. It's hidden, so it's private, and it will all be delivered to the Ronald McDonald House. We do this every year, and it was Bella's wish. It was her actual make-a-wish. This is what she wished for, and this is what we are going to do. All right, I didn't do a video yesterday because I was a little bit under the weather. I'm having more days that are good than bad, so that's a good thing. But I wanted to talk about this case out of Minnesota, and it is challenging the Minnesota law preventing people from age 18 to 20 from carrying a firearm. The case is Worth versus Jacobson. It was filed by a couple private citizens, the Minnesota Gun Owners Caucus, SAF, which is Second Amendment Foundation, and the Firearms Policy Coalition, also known as FPC. They are challenging the Minnesota law forbidding anyone under the 21 from carrying a firearm in public. The state tries to argue that the regulation is constitutional, and of course the plaintiffs in the case say it is unconstitutional. Right now it is at the 8th Circuit Court of Appeals. I'm going to go over some of the arguments and also let you know where I think this case is going because some of the stuff that the judges said. First, the main part of the defendant's arguments is that the people do not consist of people 18 to 20. According to Minnesota, they do not believe that people that are 18 to 20 are part of the people. Remember, the Second Amendment says the people should have the right to bear arms. And the state is trying to say the people do not consist of anyone under the age of 21. Of course, the plaintiffs in the case argue that that is factually incorrect and 18 and 20-year-olds are considered part of the people. If the state gets its way, anyone under 21 does not have Second Amendment rights. So let's go ahead and talk about why I think that they are wrong and what the judges actually said to them. First, there are places in the Constitution that set age limits. For example, to be president, you have to be a certain age. To be in Congress, you have to be a certain age. So we know the founding fathers, if they believed that 18 was too young, they set an age limit. But in the Second Amendment, you do not find that at all. Since they did set an age limit in other parts of the Constitution, we can only assume that they meant for the Second Amendment not to have an age limit. And yet that is what the state is arguing. Basically, Minnesota is arguing that if you are under 21, you do not have any constitutional rights. Remember, the Second Amendment is not a second-class right. It has to be treated like every other right in the Bill of Rights. And I think one of the judges actually agrees with me on this because he asked the defendant, well, if someone under the age of 21 gets pulled over at a traffic stop, do they have Fourth Amendment protections? Which is a great question because the Fourth Amendment does not have an age limit and either does the Second Amendment. So according to Minnesota, I don't think that they would because they do not believe that anyone under 21 has constitutional rights, which is absolutely ridiculous. They are trying to defend an undefendable position. Bruin said you have to look at gun laws through the lens of the Second Amendment. Basically, you have to look at the original text, tradition, and history of the Second Amendment to determine if a law is constitutional or not. The first thing you have to do is look at the original text. And if it's not in the original text, it is on the state to prove that the law is constitutional by showing analogs from the founding era. Now, there's an argument of when the founding era is. The gun rights community says it is 1791 with the ratification of the Second Amendment, which would make sense. The anti-gunners tried to throw around the date of 1868. That was the ratification date of the 14th Amendment. But the thing is, the ratification of the 14th Amendment did not change the meaning of the Second Amendment. All it did was extend the protections on the people's rights from an overbearing federal government to extend those protections to protect against an overbearing state government. So why do the anti-gunners always use this 1868 date? Well, the Civil War just ended a few years earlier, and so we entered into the Reconstruction period. During the Reconstruction period, there was a lot of racist Jim Crow laws. Basically, the plantation owners were afraid of the formerly enslaved people of getting firearms and exacting revenge. So they put in all these racist laws to prevent black people from owning guns. So there's a lot more analogs from that era. So the anti-gunners always use these racist gun laws as their analogs. Most courts have rejected that. There have been a couple different panels that have decided to go with the 1868 date, one of the 11th, but that's going to get reversed. That case was granted en banc, so it's going to the full bench. So it's like that hearing never even happened. Minnesota even tried to argue that the founding era did not end until the end of the 19th century, which is a bunch of poppycock. And I don't think that the judges were buying what they were selling. They were very hostile to the defense. So if you look at that, I would say that the plaintiffs have a great chance of winning. It is a court system, and you can never be 100% sure what a court is going to do, but I believe that the plaintiffs will win this. Now, let's say the plaintiffs do win. What will be the state's next step? They could do two different things. They could ask for an en banc hearing where the full 8th Circuit Court of Appeals will hear the case. I'm not sure if that's a winning strategy or not. The 8th Circuit has a slight conservative majority, so we might win there. Another thing that they could do is go ahead and file a writ of certiorari with the Supreme Court and ask the Supreme Court to go ahead and hear the case and issue an opinion on it. I'm not sure which way they're going to go. I get a feeling that they probably will go en banc if they do lose the 3-judge panel decision, but that is just a guess. They could also do nothing, but I do not see that happening. So no matter what, this is not the end of the battle. It is still going to continue probably for a couple more years, but this might be the case that ends prohibition on people 18 to 20 from carrying a firearm in public. That would be a good thing because 18-year-olds have just as much right as you or I. Basically, they can vote. They should be able to carry a gun. That is what I think. If they are not mature enough to carry a gun, maybe they shouldn't vote. I don't know. What do you guys think? Let me know down below. Remember, you can go ahead and buy a toy or some supplies for a family with a kid suffering from cancer that is at the Ronald McDonald House. All right, guys, that is it. So stay ever vigilant, stay ever free, keeping the fight. I am out of here. Wolverine's motherfucker.